I'm Katya Sverdlov, an attorney that helps people plan for and deal with incapacity and death. Today, I'm going to discuss the most common statement that I hear from my clients. The statement is, I just need a simple will. I hear this from 90% of the people who walk through my door. Guess what? 90% of them are wrong. It's normal. Most people do not study wills and trusts. They do not even know what their legal issues they may have. Let me walk you through just a few examples and show you where the complications may arise. First, let's talk about the family. If you have a significant other, congratulations. I hope that you live together for a long time. But let me ask you some questions. Are you married? Is it a legal marriage or a common law marriage? Is it a first or a second spouse? Do either of you have children from prior relationships that you want to protect? Do you have a divorce decree or a prenuptial agreement? Are you worried that in the event of your passing, your significant other will remarry? All of the issues that I just brought up require discussion and careful planning. Now, let's talk about children. If you have them, congratulations. Children are a blessing. I know I have 2 teenagers. Let me ask you now some questions. If your children are minor, who will be their guardian, making the legal decisions for them? At what age should the children receive money outright? Who will manage the money while the children are young? If your children are adult, do they have any issues? By issues, I mean special needs issues, mental health issues, divorce issues, drug gambling addiction issues, creditor issues, stupidity issues. All of these require specific drafting. If you are not married, and if you do not have children, you should still think about careful drafting. How do you distribute the money? Who will be in charge to ensure that your wishes are carried out? Do any of your beneficiaries have issues that prevent them from getting money outright? Are you disinheriting a close family member who is going to get upset and then will contest the will? What happens if one of your beneficiaries predeceases you? This is not a simple will. All of this is overwhelming. Yet it still only relates to issues that arise when thinking about your family. Remember, there are also issues that arise when thinking about your assets. Do you own the house outright? Or do you own it jointly with the right of survivorship? Do you have assets that have listed beneficiaries? These go outside of the will. I get it. It's a lot of information. Some people get overwhelmed and decide not to do anything at all. But if you do not plan, the state will make all the decisions for you, and your family is likely to fight. Having a well thought out will empowers you to leave a loving legacy. So now the question is, are you going to leave a simple will or a thoughtful one? Click on the link below to learn more, and you will receive information from me regarding proper planning.